Good morning, everyone. So for today's, I would like to share my knowledge about my topic. That is all about prosecution and its function. So when we say prosecution, it is a process or method whereby the accusation are brought before a court of justice to determine the innocence or guilt of the accused. Where they gathered necessary evidence with the help of the law, and they determine the existence of prima facie case. Generally, they file and prosecute the case in court, na kung saan meron silang pangunahing agency ng government. And it is the DOJ, or ito yung tinatawag natin na Department of Justice, na kung saan makukuha ang hustisya laban sa akusado. The Ombudsman, COMELEC, and others agency na makakatulong para sa atin. The role of prosecutor. They is the serving as a lawyer or state or government. The prosecutor will be the representative in different criminal cases. Or they call the abogado, lawyer of the people in the Philippines. So, they have the prosecutorial discretion and selective prosecution. Wherein prosecutorial discretion, the prosecutor screen and evaluate the documents whether that it's sufficient na mag-file ng kaso. While in selective prosecution, they evaluate the evidence that gathered or accumulated of our PNP, whether it is sufficient to warrant na the filing of charge against violator. As the legal factors considered by the prosecutor under selective prosecution, the legal strength of the case, malakas o may laban ba ang isang evidence, as the suspect is in fact guilty, kung ang suspect ba ay totoong may sala, and the willingness of the witness to testify, kung gusto ba ng isang tao na tumistigo laban sa suspect. Last is the likelihood that the prosecutor can legally prove the defendant's guilt, o kung gusto ba ng isang prosecutor na ang isasampang case mo ay maaprubahan at mapapatunayan kung sino ang guilty. Dumako naman tayo sa controversial expression of the prosecutorial discretion. The decision to mitigate the defendants through reducing the charge, tulad ng murder to homicide, dropping multiple counts to leave a single charge, o yung isang complex crimes lamang, the recommending leniency to the court at sentencing parallel prison sentence, or mas tinatawag na lighter stage lamang. Who composes the prosecutor, o kung sino yung nag-compose ng prosecutor. Nandyan ang public prosecutor for the fiscal, and under of what we have the state prosecutor, provincial prosecutor, city prosecutor, special prosecutor, and as long as the attorney in private practice, the public defender such as our PAW, and either legal and the lawyer, the IBP. So, meron ang duties ang prosecutor. They evaluate police finding. Ine-evaluate nila yung mga ebidensya na nakahalap ng ating kapulisan. Next, file corresponding information in court. As usual, nagpa-file ang prosecutor ng impormasyon sa ating court. And last is prosecutor, the alleged offenders. At ang prosecutor ay gumagawa ng mga paratang sa mga nagkasala. Dumako naman tayo sa preliminary investigation, ang inquest proceeding. Sila ang nag-determine kung meron bang probable cause para makapag-file ng case. kung meron bang dapat patunayan. Pag sinabing probable cause, kung ito'y ba yung ay may prove ukol sa pagkakasalang nagawa. Under ng preliminary investigation, meron silang provincial or city fiscal, their assistants, the national and regional state prosecutors, such as other officers as may be authorized by law. Nabanggit din ang null prosequi. It is a request made by the prosecutor to the judge for approval to terminate further criminal prosecution against suspect. Ang prosecutor ang gumagawa ng request at sila din ang nag-a-approve ng terminate the criminal prosecution against suspect. And under of that, they have reduced case overload, reduced backlog, and reduced delays in bringing defendants to trial. No, so stop. Stop mo na. Kakat ko na lang. Kasama din sa prosecutor ang arraignment. Ang arraignment, it is a legal mechanism whereby an accused is brought in court, before the court, wherein the complaint or charge against him is read by the clerk of court in the presence of a lawyer and the prosecutor, in which the accused is to announce his plea. So, para mas madaling maunawaan, ang arraignment ay ang pagbasa o babasahin ng mga sakdal sa ating akusado, at ang plea ay ang paraan para tunungin ang suspect kung ito ba ay guilty o not guilty, at kung siya ba ay aamin o hindi aamin sa ginawang pagkakasala. Plea bargaining, it is the process of discussing or negotiation between the defense counsel and the prosecutor aimed to reaching an agreement whereby the prosecutor uses discretion to obtain from the judge a lighter sentence in exchange for the defendants entering a guilty plea. Para sa bargain, yan yung makikipagtawaran si prosecutor. So, ang plea bargaining po ay ang kasunduan ng ating prosecutor at ng akusado, kung saan ang akusado ay umaamin na nagawa niya yung krimen para sa mas mababang sakdal o hatol ng ating hukuman. Ang advantage at disadvantage ng plea, so dun muna tayo sa advantage of plea bargaining. It allows the court to control overcrowded dockets. It allows the prosecutor to secure the conviction had arrest, a necessary discretional tool or for tempering the letter of the law with an individualized justice. Acts in the best interest of society rather than on behalf of the victim. Save the victim from humiliation and trauma. And last is, there is no trial. So, dumako naman tayo sa disadvantage of plea bargaining. Ang una ay, it lowering of cases, demoralize the police, provides an opportunity for the prosecutor and defense counsel to place their economic and occupational needs ahead. Mostly in favor of the defendant, it is not an evidence of repentance, legitimacy of punishment and rehabilitation. Undermines the basic premise of crime and punishment. Destructive of the adversary method of justice, and thus is defendants are dissatisfied. So, nalaman na natin ang disadvantage at advantage ng plea bargaining. Susunod naman natin is yung prima facie evidence. So, ano nga ba ang prima facie evidence? It is such as establish a fact and unless rebutted or explained by evidence becomes conclusive and it is considered as fully proved. Dito sa prima facie evidence na kailangang i-establish ng prosecutor para magkapag-file ng kaso. Ay yung tinatawag na paunang impression sa isang kaso. Kung walang prima facie, walang mangyayari sa kaso. So, nalaman na natin ang prima facie. Dumako naman tayo sa complaint. Ano nga ba ang complaint? Complaint, it is warm written statement that charging a person with an offense subscribed by the offended party, any peace officer or public officer charged with the enforcement of the law violated. Irereklamo mo ba o ihahabla yung tao? At ang pwede mag-subscribe o pumirma o maghabla laban sa taong iyon ay ang offended party or the victim. Pwede din or complainant or any public officers na charged sa pagpapatupad ng batas natin. So, what is the requisites of complaint? Written statement under oath o yung sinumpaang salaysay signed by offended party or any peace officer or public officer charged. So, natapos na natin yon. Dumako naman tayo sa information. Sa information, it is an accusation in writing charging a person with offense subscribed by the prosecutor and filed with the court. Ang ibig sabihin nito ay ang information po ay sinusubscribe o pinipirmahan ng mga public prosecutor. Sila ang piskal na tinatawag. Sila ang nagpapile ng information sa court. So, what is the requisite ng information? A written accusation. Inaakusahan ng isang tao. A person is charged of an offense and then signed by the public prosecutor. And the information is filed with the court. So, pumunta naman tayo sa purpose of preliminary investigation. Ang una nitong purpose ay, first is to protect the innocents against hastily, malicious, and oppressive prosecution. Sasalain muna ng mga taga-usig o prosecutor kung meron ba talagang basehan o probable cause ang isinampang kaso laban sa respondent. Next is to spare him for trouble, expensive, and anxiety to public trial. Ang pagsasampa ng kaso sa korte ay gagastos na kahit na may PAW o Public Authority Office. Next is to protect the state itself from useless and wasteful rights. So, ito na yung other officers authorized by law. So, sila ang COMELEC. They conduct preliminary investigation on all election cases under the Omnibus Election Code 1987. Sa Constitution mandates the COMELEC not only to investigate but also to prosecute case of violation of elections law. So, ang ibig sabihin, di lang pakandak ng preliminary investigation ang pwedeng gawin ng COMELEC, but also to prosecute yung mga kaso laban sa mga violation ng mga election. We have the PCGG. It is the Presidential Commission on Good Governance. Prosecution for violation of Republic Act 3,100 at siyam or yung Anti-Grant Law and Republic Act 1379, Unexplained Wealth. The Office of the Solicitor General can legally represent respondent government of official in preliminary investigation. the Prosecutor Office on charge of violation of anti-grant law. So, ang nagkakandak para sa violation nga, anti-grant law and unexplained wealth ay ang PCGG. So, meron tayong tinatawag na tanod bayan and his assistants. Ang tanod bayan ay hindi yung tanod na sa ating barangay. Ang tanod bayan ay ang ombudsman ng Pilipinas. Maliwanag yon. Dako naman tayo sa military tribunal government by Articles of War. The Metropolitan Trail of the NCR and the ROTC judge are no longer authorized to conduct preliminary investigation. So, napaliwanag ko na sa inyong mabuti kung ano ang prosecution. And dito na natatapos ang aking mga napag-aralan at mga opinion ukol sa aking napanood na video. Maraming salamat po.